Hello, my name is Daniel Fong. I'm certified by the California State Bar as a specialist in trust, estate planning, and probate. Welcome to my channel, Fong Law. Today I'd like to discuss a topic. Should you omit your children's names in your estate planning documents if you don't want to leave anything to them? Recently, I've come across a case. A man had married twice. He had 2 children with his first wife. After he divorced his first wife, he remarried, and he had 3 children with his second wife. The second wife did not want this man to leave any property to the children from his first wife. So when this man set up a trust, he did not leave anything to the children from the first wife, and he did not even mention the names in the trust as if they never existed in the world. When this man died, the 2 children from the first wife filed a lawsuit to contest the will. They claimed that their father, when he executed the trust, lacked capacity. Due to his lack capacity, he failed to mention their names in the trust. The result is that the 2 children won the lawsuit. The judge ruled that the 2 children from the first wife were entitled to a share of this man's estate. What are the implications of this case to our audience? Many people don't want to leave property to their children for many reasons. One of the reasons is what I have just mentioned. They don't want to leave property to the children from their ex-spouses. Another reason is that they have a bad relationship with the child. They have lost communication with the child. Sometimes they may not even know where the child lives. Another reason is that one of the children is doing very well financially, but the other children are not doing really as well financially. So they feel that the well-to-do child don't need their money. They rather leave the money to the less well-to-do children. Another reason is that they want to leave their property directly to their grandchildren instead of their children. So when they write their wills or trusts, they did not mention the child's name, the name of the child whom they don't want to disinherit. They feel that as long as they don't write their name down, everything will be fine. However, the law does not look at it this way. The law presumes that your children are your natural bounty. If you don't mention your children's name in the documents, it's probably an oversight. If a disinherited child file a lawsuit to contest a will or trust, then very likely the will or trust will be invalidated. In the case I have just mentioned, I don't know whether the man intentionally did not mention the 2 children's name to the attorney, or he did mention the name of the 2 children from the first wife to the attorney, but the attorney failed to mention them. If it is the latter, then the attorney may be sued for malpractice. Then, if you don't want to leave property to your children, what should you do? What I normally do is that I will mention the name of the child whom the client wants to disinherit in the documents. But then I will say that the client intentionally does not want to leave anything to the child because the clients have provided what the child deserved during their lifetimes. This tactic has 2 advantages. The first advantage is that the client do mention the names of the child whom they want to disinherit. That means that the clients did not forget the children. Rather, they have made a conscious decision not to leave anything to the child. And second, the client mentioned that the reason why they don't want to leave anything to the child is because they have provided to the child what the child deserved during their lifetimes. What did the client provide to the child? Education, food, and shelter. So there's no argument here. Some clients ask me whether they should be more specific in explaining why they don't want to leave anything to the child, such as the son failed to communicate to me for 5 years and failed to visit me when I was sick. I don't see no reason for doing that. Because if you are so specific in your wills and trusts, then it may arouse unnecessary resentment. If this is the case, then the disinherited child who would not have the intention of filing a lawsuit may file a lawsuit. And the purpose of the lawsuit is not get a share of the estate, but rather to prove that he's not such a bad person. And some people say that even if you don't want to leave anything to the child, you should not say that you leave nothing to the child. Rather, you should say in your wills and trusts that you leave $1 to the child. Many people, including some lawyers, believe that a client should not leave nothing to the children. Rather, they should leave them $1 or $100. Then they would not have an excuse to file a lawsuit. In my opinion, that really doesn't solve the issue, because the child who get $1 or $100 may still file a lawsuit, saying that this is unfair to them. Moreover, the child who get $1 may take it as an insult. So a better way is to say that you don't want to leave anything to the child because you have provided to the child what the child deserves during your lifetime. And there's another problem with leaving $1 to the child. If this case goes to probate, the child who got $1 will get involved. If the child refuses to sign certain documents, such as receipt of $1, that may unnecessarily prolong the probate process. So if you don't want to leave anything to your children, you should do it carefully and prudently. You should consult an estate planning attorney. I'm Daniel Fong. Thank you for your time.